way of some background, for all of these organizations complained against in the three accidents, they were the employers of the complainants. And because of various deficiencies of these organizations in the handling of employment data, which resulted in the improper disclosure or unauthorized or accidental access, processing, or use of personal data, these organizations in question were found to have contravened the PDPO. So I'll first talk a little bit about the requirements under the PDPO. Under DPP 3(1) of Schedule 1 to the PDPO, it stipulates that personal data shall not, without the prescribed consent of the data subject, and when we talk about prescribed consent, we mean consent voluntarily given by the data subject, be used, including disclose or transfer for a new purpose. And when we talk about a new purpose, we mean a purpose which is unrelated or not the original purpose when collecting the data. Furthermore, under DPP 4(1) of Schedule 1 to the PDPO, it is stipulated that all practicable steps shall be taken to ensure that any personal data held by a data user should be protected against unauthorized or accidental access, processing, erasure, loss, or use. So for case number 1, it involves a security service company which sent a notice of termination of employment issued in respect of a particular employee to a chat group in an instant messaging application. So the complainant worked for a security service company. She was posted to a leisure facility. And when the complainant's supervisor issued a notice of termination of employment to that complainant, he sent a notice to an instant messaging chat group, which was set up for work purposes. And this resulted in the disclosure of the complainant's personal data contained in the notice, which included her name, her Hong Kong ID card number, and information relating to the complainant's dismissal to other staff members within the group. So when asked, the company explained that because there was the need for members within that chat group to know that the complainant could no longer access staff-only area of the relevant venue or internal information of the company after her departure. So it was why the complainant's supervisor sent the notice to the whole group. And the supervisor did so hastily and without due consideration, so that he failed to redact the personal data contained in the notice, which should not have been disclosed to other third parties. And after investigation in this case, the Privacy Commissioner considered that disclosing the Hong Kong ID card number and the dismissal information of the complainant contained in the notice would be beyond the original purpose of using the data, which was basically to handle the complainant's employment matters. And because the disclosure was not for the original purpose or any directly related purpose, so it amounted to using the data for a new purpose. And as I've mentioned just now, because the company did not obtain the prescribed consent, meaning the voluntary consent given by the complainant before using the data for such new purpose, so the company had contravened the requirement of DPP 3(1) of the PDPO as regards the use of personal data in the present case, and the PCPD has served an enforcement notice on the company in this case. Moving on to the second case, it concerns the security department of a hotel, which failed to lock the work drawer after putting all the staff annual performance appraisal forms inside. So the complainant was employed in the security department of a hotel. She inadvertently discovered the annual performance appraisal forms of all the departmental staff in an unlocked drawer when the complainant was looking for other documents at that desk. The desk was located inside the control room, and the desk was primarily used by the department head. But the thing is that even though it was primarily used by the head of the department, head of the security department, when that department head was on leave, in fact, the security staff could use the very same desk to handle paperwork. And as a result of the inadvertent discovery of those documents, the complainant managed to see the personal data of other departmental staff, which included their names, their dates of joining the company, and also their performance appraisals. When asked, the hotel explained that the incident happened because the department had forgotten to lock the desk drawer after placing the appraisal forms inside. And after learning about this incident, the hotel had taken disciplinary actions against the head of the security department for failing to properly safeguard confidential documents such as appraisal forms in accordance with the relevant guidelines and relevant rules. And the hotel had also imposed requirements on the safekeeping of such documents by the security department head. As a result of this investigation, the Privacy Commissioner found that the hotel had not taken all practicable steps to ensure that the personal data involved was protected against unauthorized or accidental access, processing, erasure, loss, or use. And therefore, it had contravened DPP 4(1) of the PTPO concerning the security of personal data. And in this case, the PCPD has also served an enforcement notice on the hotel. Moving on to the third and final case, it concerned a social welfare organization which mistakenly saved a scanned copy of a document relating to staff dismissal in a shared folder. So the complainant was formerly employed by this social welfare organization, and when processing the written record of the complainant's dismissal, an officer of that organization scanned the document but mistakenly saved that scanned copy into the department's share folder and within the organization's internal information network. Because the document was also not encrypted with a password, so that relevant document, which contained the complainant's name, date of joining, her salary, performance appraisal, and reasons for dismissal, etc., was accessible by all staff members within that department. When asked, the organization admitted that the incident stemmed from human error of an administrative officer who mistakenly selected to store the scanned copy in the share folder when scanning. So the document was deleted immediately after the staff learned about this incident. And the organization stated that the document remained in that share folder for about half an hour, and there was no record of any other staff having accessed it. As for remedial actions, after the PCPD investigation, the organization had attended to the matter immediately, and it has also debriefed the relevant administrative officer. And the department in question also disabled the function of allowing scanned copy being saved onto that share folder. And the organization also reminded all the staff during the departmental meeting that they have to be extremely careful with sensitive personal data. This organization also arranged regular training for staff in respect of the protection of personal data privacy. And having considered the circumstances of this case and also the information provided to this office, the Privacy Commissioner issued a written warning to the social welfare organization for having contravened DPP 4(1) of the PDPO concerning the security of personal data.